a box of Cheerios, Betty Crocker cake mix, or hamburger helper in your pantry, you may want to know that General Mills has a new legal policy that critics worry could absolve the company of accountability for its products. The company quietly updated its privacy policy and directed people to read it on its website, which you see here. The new rules appear to prevent anyone from suing General Mills if they download coupons, enter company sweepstakes, or even like their page on Facebook. It says disputes would instead be resolved by informal negotiation or arbitration. A spokesperson from General Mills denies reports that the legal policy means customers can no longer sue the company, telling us in a statement, quote, "This is being broadly mischaracterized. No one is precluded from suing us merely by purchasing our products at the store or liking one of our brand Facebook pages. That is just a mischaracterization." So, here to discuss the change is Domenic Romano, founder and managing attorney at Romano Law. He specializes in business law. Mr. Romano, thanks for being with us. So who's right? Can you still sue General Mills if you have a dispute over one of their products?
Not if you join one of their online communities, download a coupon from their website, or enter into one of their contests.
So that's black and white to you. It is not a mischaracterization, as the company has told us.
No, the company's statement after the New York Times story came out, the clarification was merely liking the company on Facebook or following it on Twitter will not cause people to into forced arbitration consumers. But they did clarify that purchasing one of their products or subscribing to one of their services through their website does bind the consumer to that forced arbitration. So the consumer is giving out a right to jury trial, right to participate in a class action, and any kind of court action.
Is this legal, or does this need to be cleared by the courts?
It's a very good question. The court in 2011, the Supreme Court allowed companies to have agreements whereby consumers would opt out of class actions. But this creates an unequal bargaining power for people, the individual against the big company. And a lot of times, these large corporations will control the arbitration process. Consumers will have to travel to places like Minneapolis to resolve disputes in front of an arbitrator. So it's more costly and time-consuming, and there aren't exactly equals against.
Is this something that a lot of companies are doing, and we are only finding out that GM is doing it? Is this a trend that we're seeing elsewhere?
We've been seeing it a lot in the last few months, even. Dropbox, earlier this year, amended its terms of service to allow for arbitration. Starbucks gift cards. If you get a gift card from Starbucks, in certain circumstances, you will basically waive your right to litigation.
As you mentioned, the Supreme Court has tended to be sympathetic recently with companies and class action suits. Would you expect there to be an immediate challenge in court on something like this?
You know, it already set off a firestorm across the internet. People objecting, people posting on the Cheerios Facebook page that they do not agree with this change and are opting out. I think you're going to see some challenges for sure.
What can a consumer do short of not buying their products? And by the way, they don't just make cereal. General Mills owns all sorts of other packaged goods.
Yes, everything from Lucky Charms to bars. But what a consumer can do is not participate in those online communities, not download coupons, not join their contests. If you buy a product in the store and are not otherwise engaged with the brand online, you're not waiving your right to sue.
Okay, that's important to say. Well, there's certainly going to be a lot more on this. Domenic Romano, founder and managing attorney at Romano Law, thanks so much for your insights.